to Legally Speaking. With me, Tarun Nangia. The Chief Justice of India, Justice N.V. Ramana, made a very interesting comment on the Central Bureau of Investigation and the Enforcement Directorate. He said that if there is something in an investigation, the agency should file a charge sheet and do not keep it hanging. But what he said after that is even more interesting. He went on to say that there is one case in which you have attached properties worth rupees 200 crore, but nothing has been filed till now. Particularly with the Enforcement Directorate, nothing is moving. Of course, he went on to make further comments on the functioning of the Enforcement Directorate and CBI. He also admitted that there are infrastructure issues, but on the attachment of properties, his comment was very clear. We have 3 lawyers who do a lot of work with the Enforcement Directorate, with some of the best and the top clients in the country, the businesses, and they understand what issues businesses face when the assets are attached and how does it impact the business. So I will introduce you to my panel today. I have with me Advocate Vijay Agarwal, who joins us today. I have with me Advocate Vikram Chaudhary. I have with me Advocate Abhimanyu Bhandari. Welcome all of you for innocent sparing joining me at the same time at a short notice. We will first start with Mr. Vijay Agarwal. Can you give us the opening comment on what do you make of the Chief Justice of India's comments?
See, Chief Justice comment, I agree with, I echo the same sentiment, but with respect, it is legally incorrect comment because as per section 8, subsection 3A, PMLA Act, if something is attached, it continues only for 365 days. So legislature has taken care of the same. So it was a recent amendment, so maybe it skipped the mind. So now legislature has taken care of it. If ED attaches anything and the charge sheet is not filed, it continues only for 365 days. So like you might have heard that if a charge sheet is not filed or a complaint is not filed, a man who's been arrested gets released within 60 days or 90 days. Same thing is for the property also now. So it comes with an expiry date. But I do agree that the investigation keep on continuing. At times, they rather my problem is not that they don't file a complaint. My problem is if a man is arrested, they file an incomplete complaint so that the man continues in incarceration and they keep on continuing to further investigate. So the Chief Justice comment ought to be that there should be limit to this further investigation. Investigation should stop because as per the judgment of Vino by Justice Rohington Nariman, now the trial, after the charges, investigation cannot take place. So the trial doesn't start till the investigation is there. So this is the problem in this.
Okay, point very well taken. This was Advocate Vijay Agarwal. You saw him recently defending Chanda Kochar, if not wrong, in a matter recently. You were all over the press and of course some other clients. I have with me Vikram Chaudhary, another lawyer who represents high-profile clients in the Enforcement Directorate. I think I saw him in the Sansera matter in Gujarat. I think this was a couple of years ago. The Chhagan Bhujbal matter also, in which I think even Mr. Vijay Agarwal was involved. But how would you look at the comments of the Chief Justice of India?
See, Tarun, we have to first see the perspective in which the comments are made. I believe the comments are divided in 2 spheres. There are 2 different spheres. One is relating to attachment of property. The other is where investigations are incomplete. And the main, I would say the rub appears to be where the trials are prolonged. There's no speedy trial going on despite the mandate that they should proceed on a day-to-day basis. So all 3 things put together. So we have to first see it in perspective. When we talk of attachment of property, we must know that property is a constitutional right under our Constitution, Article 300, capital A. And it is also recognized as a human right in several precedents of the Supreme Court. Now, the legislature, parliament, though provides for attachment of property, but I think it is with a heavy heart because there is a procedural mandate which governs the attachment of property. It cannot be casual or arbitrary. It has to follow a complete procedure which is set up for it. Various enactments, including PMLA, where Mr. Agarwal, my brother, just referred to, PMLA has its own checks and balances. There are several examples today, and since the matters are sub judice, we won't like to comment much except saying that we have seen transgression of such powers. And that has led to a situation of kind of an impasse. Why an impasse? Because if the powers are exercised in some kind of a casual, arbitrary manner, then it leads to multiplicity of litigation, eventually leads to choking the administration of criminal justice system. There has to be, no, I'm not saying that property should not be attached. PMLA postulates that property should be attached only when it is likely to be disposed of or pilfered away to frustrate the proceedings under the Act. Now, if the property is already, say, under charge or lien or mortgaged with banks, where was the, at first of all, necessity to do it? Second, PMLA also imposes a rider that unless a charge sheet is filed in scheduled offense, you would not attach. And also gives a leeway to the enforcement directorate that you could still attach even if charge sheet is not filed in the scheduled offense, where there is an emergent likelihood of its disposal, etc. On all stages, reasons to believe have to be recorded. Recently, Supreme Court in 2 judgments, Opto Circuit and Radhakrishnan Industries, has come down heavily, where bank accounts were attached by not following the correct procedure. One was under the GST Act, the other was under PMLA. So we are now in a situation where property is required to be attached, the necessity to attach. Second is the formality to attach. The necessity vis-a-vis formality. I am doing a case in Delhi where a person in the scheduled offense was a Narcotics Act case. He is acquitted. In PMLA case, he is discharged by the trial court. The directorate goes in revision before the High Court against the discharge order and takes an order that so far as attachment is concerned, it will continue. The attachment in that case was that of a residential home of that man, where there are 2 brothers, their families, children are residing, their education books are also lying in the house, and the house is locked. It is in the city of Amritsar that house is located. And there were reports that there have been many thefts taken place during the seizure period. So we went and approached the High Court that it should now, since I have got these 2 orders of discharge also, at least the property, we should be able to enjoy the property. Why should they take possession?
Point very well taken. A good point you made, that if the property is mortgaged with the banks, why do you need to attach it? There is no way that the accused is running with the property. Abhimanyu, talking of properties, I saw you appearing for the promoters of Unitech not too long ago. You have an exposure to these kind of cases. Now, I will take this discussion a bit ahead. That Justice Dhananjay Chandrachud also said that just 2 days ago, we had a 1995 TADA case in which charges were not even framed. So there is one thing about, delaying in filing the charge sheet, and another what Justice Ramana said about the attachment of property. What is your understanding of this issue, and how would you take the comments of the Chief Justice of India?
Okay, so I really echo the sentiment and the comments that the Honorable Chief Justice has made. I think he really got it right. And I would say that we are living in a situation where I think there is nothing but only chaos. And I tell you why. Look at it from the business perspective. We all know that secured lending is the edifice of economy, is the edifice of banking industry. Any economy will grow if a lender can give loans on the basis of getting security. And the lender should be able to realize the security quickly. By having this PMLA Act and by allowing enforcement directorate, as you just mentioned, to attach properties which are mortgaged, you have really, what you have done is that you have tempered the severity of all these securities which lenders give. Do you know what a chaos there is going on right now? There are a large number of cases where banks have gone and complained to the CBI and ED that, look, this person promoter has run away with monies. Instead of helping the banks, the ED has gone ahead and has attached the same property which the bank has taken as security, which was given against the loan. So now the bank is worse off because neither the bank can sell that asset and realize its money. Now remember, these are plant and machinery, and therefore they're depreciating. There are cases from 2015 pending. where these assets remain attached. We have a one-man adjudicating authority which looks after the whole country. We have no appellate tribunal functioning on final hearings for the last 2 years because there has been no quorum. So things are in a real disarray and attachments are going on increasing day by day. Therefore, we urgently need, it's all very well to say, let's finish investigation quickly. Why endless investigations? But the real situation is that we need to bring in some kind of an amendment to ensure that properties which have been mortgaged and given to banks as security cannot be attached by any investigating agency, because this will really create a chaos in secured lending and will further plunge ease of business, which our country is trying to achieve as a broader target. The comment that Mr. Vijay Agarwal made, that section 8.3 comes in, and therefore within 365 days, even if there is no charge sheet, the attachment ceases to operate, technically looks good. But really, I ask myself that, does this really solve the problem? No, rather it, I think, has a worse impact. The impact is that now we have a time mandate so that investigating agencies rushed into filing a charge sheet within 365 days. And then we see incomplete, inchoate charge sheets coming in. And therefore, what is happening is that further turmoil is being created because people who probably should not face a charge are just being put in a charge sheet to somehow save an attachment of a property, so that then they spend many years trying to get rid of that attachment. So I think rather than helping, that is worsening the rights of secured lenders and also interfering and harassing innocent persons who should not have failed attachment in the first place. So, I fully support the comments that the Honorable CJI has made. And I really feel that this whole system of attaching properties, whether it is under the GST Act or whether it is under the PMLA Act, needs to be completely relooked. When I was writing my book, Tarun, I went through the laws of UK, EU, and US. In all these countries, I did not find a single example where a lender, a big lender who has given monies to a company to build plant and machinery, his security is attached because he has complained that the promoters of that company has run away with the money. So really, you have put a lender between the deep blue sea and the devil. If he complains, the devil will catch him. If he doesn't complain, he will sink in the deep blue sea. So I think we need to completely rehaul our system. Second, like the UK, we should further strengthen our systems so that attachment is post-conviction and not before conviction. If you want to urgently attach an asset pre-conviction, like learned senior Mr. Vikram Chaudhary said, that then you have to really show that there is some urgency, that the asset will disappear. Because if you can't show that urgency, then you cannot. And I think pre-conviction attachment should only be done at the High Court level and should only be done by a judge. So ED can, of course, move an application before a judge saying, please, we feel this asset should be attached, but whether it should be attached or not attached should not be an issue which the ED should decide. It should be an issue which a judge sitting, hearing both the parties, should decide whether it is in the interest.
You made a very important point. I would like to get the panel in. Mr. Vijay Agarwal, should a judge decide on the attachment of property now? Can it be possible? Can a direction be issued by the judiciary that the judge will decide henceforth whether the ED has, in a sense, the right to attach property?
See, again, I would say that legislature has taken care of it. Asset can be attached. See, one thing is not having a provision in law. Second thing is that the executive not following it. Like they are supposed to record reasons to believe, they have to take steps. But I think it would be ludicrous to say that the court should be attaching it because it is the executive power. We must understand that executive has to do their job, and whether the job of the executive is correct or not, that is for the judiciary to see. And suppose like you say, a number of cases like my clients, Nirav Modi, Mehul Choksi, like if they go to the court, by that time property is nowhere. Property will evaporate in the thin air. So this is it. So executive in a given set of circumstances has to attach immediately so that the property doesn't evaporate overnight. There is no time enough to go to the court. So tomorrow you will say that why property? Then before arresting also you should take an approval. See, what is more important, a property or a liberty of a person? So for liberty, do you need the power of a judge or a court order? No, you can go and arrest a person. So the executive power has to be there. So it is easy for us to say in the AC rooms, saying that, okay, executive is doing everything wrong. And my experience is that ED is an intelligent agency. ED officers, though I don't want to make comparisons and say draw are from the other investigating agencies. I mean, they come from enforcement directorate cadre or income tax cadre. They're extremely intelligent people, and we struggle because we have to swim against the flow. They do a good job, but the only problem is that they do not follow the law. I have no problem with the letter of the law. I have a problem with the non-follow-up. I'll just make one point on lighter side. When you opened, you said that, Mr. Agarwal, what is the problem when they attach? I have a personal problem also, Tarun. They do not leave the money with the client to pay lawyers. They come and attach. So the lawyer should get engaged first, and then they should be attaching. That would be my personal request to the legislature.
Isn't this a serious enough issue?
Yes, it is indeed. And please see, in 2G case, I got acquittal, even still the assets are lying attached, because in the appeal they have taken a status quo order. So this 200 crores seems to be interesting numerology. In every case, they seem to be attaching 200 crore of rupees. In 2G case, despite the acquittal of all my clients, they have gone in appeal and taken a status quo order. Money is lying still pretty. The assets are lying still pretty. And those 200 crore today are 20,000 crores. This is it.
Mr. Agarwal, I hope you are paid by your 2G clients. If I'm not wrong, a lot of your money remains unpaid, but I think you are more than charitable. We will go to Mr. Vikram Chaudhary. Sir, if I may ask you, Chief Justice of India, Justice N.V. Ramana, also in a sense spoke of the plight of the agencies, that infrastructure and manpower are big problems to investigate a matter. And he says in one CBI court, there are 900 pending cases. Now, 900 is a huge number for a single court, and CBI cases pending. So I would request you to comment on the earlier comments made by Tari and Mr. Agarwal, and also on this issue.
So, Tarun, as I said, we have to reconcile and harmonize various stakeholders in the administration of criminal justice system. So the first stakeholder in a given case, we are talking about enforcement directorate, PMLA. Well, there are cases, other cases also where there are victims, like say banks who have been defrauded, or the other private victims. So we have to balance the rights of the victims vis-a-vis the fundamental right, a constitutional guarantee given to an accused, and also the onus and huge responsibility which lies on these premier investigating agencies. It is not easy for them to investigate a complex web of transactions which may have taken place. The only difference is that we have to actually lay down a clear distinction between chalk and cheese. So there are cases where apparently nothing is spelled out. The agency seems to be satisfied. But since the case is of such sensitive nature and there is some kind of a profile involved, well, it cannot be accorded a closure. It cannot be said that, well, nothing is found. And there is kind of a decision-making paralysis. So even if somebody has decided at some level that it should be done, there is no, I would say, courage in taking the decision. There is a fear that it may have a backlash. So you thrust everything upon the court. Let the court take a final call. That percolates into some kind of, as I earlier said, choking the administration of criminal justice system. And there are too many litigations to be handled. One is, of course, the trial. Right? The Code of Criminal Procedure has existed for more than maybe 100 years. It was in 1890 somewhere it was introduced, and 1973 revamped. We have Section 309, which says that once a trial begins, it has to be on day-to-day basis. We have Prevention of Corruption Act, which says the trial has to be on day-to-day basis. So the legislature has always been sensitive that these enactments always provide for a procedure, a speedy disposal of cases. But we have entire system choked. We have so many special legislations today which provide for expeditious disposal, maybe the Juvenile Justice Act. There are other provisions of various enactments, including these MPMLAs matter, which the Supreme Court is now handling. So all those require, I would say, harmony. We all as stakeholders, counsel for the accused, whom we mostly represent, as officers of the court, we owe responsibility that there is no frivolity. But unfortunately, wherever we meet frivolity on the other side, then it takes more time, It goes from one step of the court to the other step of the court and to the other. Like the example I was giving, the High Court gave an order that give him the house for his children to live in. He will himself pay rent of that house and deposit it in the High Court. But even that order was challenged in the High Court, in the Supreme Court. And eventually, till the Supreme Court decided the SLP and dismissed it, upheld the order of the High Court, the possession of the house was not given, which was lying vacant to nobody's use. So these kind of litigations will have to be avoided to, I would say, release this system of some kind of unnecessary litigation, which is occupying the space, whereas it could be that space could be provided for legitimate, well-warranted, and well-justified.
Very good by Advocate Vikram Chaudhary, as we can also see that our Chief Justice of India, Justice N.V. Ramana, is worried about the rising number of pending cases. And you see what he's done. You saw the appointments. 9 appointments went through within barely days of, he just took charge and these went through. The judiciary has to be commended for the vision and foresight. I think there's more to come. We'll see more appointments in the coming days. Abhimanyu, I see that Justice of India, A. Ramana, also made one more statement very interestingly. He said that the Supreme Court requested the central government to provide special courts for enforcement directorate, but central government was not able to do that. Do you think time has come that the court should, in a sense, take this up and, in a sense, somehow get special courts for ED everywhere so that these very important cases involving big businessmen get priority or at a fast track? And because, see, I have realized when I saw matters like Unitech in your case or Sansera's in Mr. Chaudhary's case, ICICI Bank, I think Avanta you're doing, all these matters, these people provide employment to so many people. So when these companies are affected, the employees and their families are affected. It's not the question of the promoter. The promoter has enough money. What do you think, Mr. Bhandari?
No, I think that to ensure that economy grows, to ensure that corporates can successfully resolve disputes, whether they are criminal or civil, and things can be taken to a conclusion, we urgently need 3 things. Let's talk about the special court is a very far sort of. First, let's look at it this way. We have we don't have a head in the NCLT, the National Company Law Tribunal. The National Company Law Tribunal deals with attachment issues also, because now there are in liquidation orders have been passed where assets can be handed over to the liquidator. Therefore, we need a fully functional NCLT. We don't even have a head of the NCLT. A retired Supreme Court judge usually heads the NCLT. We've not had an appointment there in ages. And I think this is something that we need urgently. Third, we don't have a functional Prevention of Money Laundering Act tribunal. And that is absolutely shocking. And when it was functioning also for a year, it had to have 2 members. It had just 1 member. So there were no final hearing matters heard. So we urgently need a head in the PMLA tribunal. High courts are flooded with writ petitions because aggrieved persons can't go anywhere but have to then go to the High Court. So therefore, I think that vacancies, of course, is a huge issue. And I think that what we read from the press is that Supreme Court is now dealing with it swiftly. And I'm sure that, these posts will be fulfilled, but they have to be fulfilled quickly. As far as special courts are concerned, I think that we need more than special courts. We really need more functional adjudicating authority members. And we urgently need more members in the tribunal, just not 2 members for the entire country. We at least need 4 or 5 benches, because I think now there is a tsunami of cases which are pending at the tribunal level. So yes, I think we urgently need this.
In fact, you're right. We saw some good work in Justice M.M. Kumar's time in the NCLT. But of course, as you said, and Justice Mukhopadhyay's time, some great, big resolutions happened. Of course, it was all over the press. I'll go to Mr. Vijay Agarwal. Do you echo the sentiment that we need special courts for enforcement directorate? You do a lot of these matters. What is your view on this?
Tarun, I don't know what's happening today. To every question of yours, I have to answer that legislature has already taken care of it. As per Section 44, there are special courts. As per the PMLA Act, it is to be tried by a special court of the rank of a special judge. So now what they have done in Delhi is that they have said that all the session judges will have the power to act as a special court PMLA. So in Delhi, they have made a Rouse Avenue court where they have 26 CBI judges who have the power of PMLA. And please, do not derive any numerology from the Akshay Kumar's movie Special 26. There are 26 genuine judges that we have in Rouse Avenue today. So in Delhi, there is not so much of a problem. We have some great and fast judges. The problem is with Mumbai. In Mumbai, there is only one judge for PMLA, and that judge has changed. Earlier, there was one gentleman. He was there for quite few years. After that, every judge seems to be surviving only for 6 months, and he loses the track of the cases. And there is one judge for the MP MLA cases. So in the whole Mumbai, which is the financial capital and which has got most of the cases, there are only 2 judges. So in Delhi, I don't see a problem. You've got 26 judges. The dates are fast. The problem is this only, that the agencies are not completing their investigation because they want to keep the accused on their leash all the time. That accused will come and do namaste to them all the time, and he'll be on leash, so that once the investigation is over, then it's between the court and the accused. So agency wants to keep its control. So that desire to have the accused and everything under their control is killing the system. But in Delhi, I believe that we have enough judges. There is no problem. The judges are not at all overloaded. Mumbai, there is a lot of problem.
Mr. Agarwal, so what the Chief Justice of India said is applicable to outside Delhi geographies. Delhi is fine. Looking at your, in a sense, your knowledge of legislature, we have seen a time when a lot of lawyers went to the Rajya Sabha. I leave it at that. We'll go to Mr. Vikram Chaudhary. So if you could, in a sense, extend the argument of what Mr. Vijay Agarwal said, it's just an outside Delhi problem. Infrastructure is not such a big issue. Would you agree?
See, I tell you, the infrastructure at least in the northern states, there are 2 kinds of infrastructures we are talking about. One is the infrastructure with the investigating agency, like the Enforcement Directorate. I believe there is the kind of cases that they are coming up with, and the number of cases which are constantly rising and exponentially. So they need, I think, not only well-equipped staff, but they also need some kind of, I would say, training, some kind of sensitization, some kind of acclimatization. They should know the purpose and objective for which they are there, and so that the data and evidence collection can be fast, smooth, and it does not trample upon the rights of anyone. That's one infrastructure we are talking about. The second infrastructure, same as with the CBI, an overburdened agency with, I think they also require more appointments. It needs to be more branched out and having more experts on the field. The second infrastructure is the court infrastructure. So court infrastructure, as my brother, Mr. Agarwal, rightly pointed out, the court infrastructure is, I would say, at certain places, it is very well in place. The problem lies with the approach. As my friend just used the word that the investigating agencies keep the people on the leash. So we have not even seen a single PMLA case where, despite somewhere I think the trials have also concluded, but the investigations are still on. We do not see what kind of investigation is this which will never end. So once it is unending.
Taking this point, I want to, before we end the show, do a quick round of questioning with all the General Tushar Mehta submitted before the court. And I may like to read it out. For the Enforcement Directorate, what happens is that letters rogatory, which is formal request from a court to a foreign court for some judicial assistance, which are, but countries that are tax havens don't respond at all. Now, this delays the complaint and would you agree with Tushar Mehta on this count?
Tarun, very quickly, I think I agree with the comments made by Mr. Mehta. If there is no response for a long time, then things do go into cold storage. But having said that, I think that what Mr. Chaudhary has said, that even there are cases where there have been acquittals, and even after that investigation is going on, is, I think, very worrisome. So that, of course, nothing can be a justification to that. But yes, I do know that letters of rogatory do take a significant amount of time to get a response from.
Okay. That was Mr. Bhandari. Mr. Chaudhary?
See, totally agree with Mr. Mehta that in certain counts, the investigations do take some time. They are complex. There are foreign agencies involved. But that cannot be an excuse for keeping the things hanging on and not taking the things to their logical end. So to whatever extent, so whatever happens here is that Mr. Agarwal said, and rightly so, that the Act provides 360 days in which during investigation you can attach a property. But what happens is, for the namesake, and a complaint is filed, prosecution is launched, so that bar embargo of 360 days is over. But what happens eventually is that you're still investigating, further investigation is on. So though for the sake of presentation in the court, a case is filed, but the case will not proceed because investigations are yet underway.
Point taken. Mr. Agarwal, very
Yeah, it is very clear that this letter regulatory thing cannot be an excuse. And see, other governments are not responding. Recently, I had a case where the Brazilian president case, where the Brazilian government requested Indian government to attach the things, and Indian authorities went and attached for a client of mine, this Milton. The amount was $12,000, and they attached some 400 crore of rupees. Then that we got released from the court. So Indian agencies are very swift to respond. Brazilian government only said that please attach $12,000, and they went and attached all the accounts, all the FDRs, and they brought the company to a standstill for a while. So Mr. Chaudhary is very right when he says that cannot be an excuse. You have to put a man to trial. The man is in no man's land, so he does not know. And as lawyers also, we need to get fee for our trial briefs also. So the trial has to start. So one should look at the lawyers, poor lawyers also.
On that note, we will all stand.
I like when Mr. Agarwal gets some humor into the discussion. If a tax haven doesn't respond to a LR sent, what happens to the investigation?
See, investigation is not only based upon one LR. Investigation is multifaceted. It has so many other tentacles to go into. So that's just one part of it. That one part of it can't make the tail cannot wag the dog. So you have the basic evidence in place, whatever you intend to rely upon. You should swiftly make it a point that it goes for trial. But what happens is that by virtue of further investigation, where even a trial starts, it still gets interjected because you introduce more players into it. There are more people who are being interrogated. So in one case where you rely on, say, 50 witnesses, after 5 years, when the case is pending, you examine another 50 more, and you file a supplementary charge sheet or supplementary complaint, and then introduce those 50 as witnesses again. So where will the trial go? When will it conclude? It is just dragging on. And then again, less judges, that the judges are burdened, that there are more cases, they are pending since long. So it's not the pendency since long, it's these kind of cases actually which have created certain kinds of hurdles in the administration of justice. So we need to come clear on certain aspects. I think Supreme Court is presently seized of about 250 odd cases, in which many issues relating to PMLA, which I always call as still a work in progress, because constantly we raise one issue and you get an amendment in 3 months on the same issue. So whether it's by way of an explanation or otherwise. So everything is before the Supreme Court now, and I believe that once those matters are heard, there'll be a lot of clarity, at least in money laundering cases.
Mr. Chaudhary just touched upon a very important issue. They are making amendments in PMLA as a finance bill. They are not passing it properly. So for that, there is a writ petition pending. So whatever we lawyers take a point, what they do is that they come and amend. So lawyer proposes, and they have an amendment for that. So whatever we propose, they dispose it of through an amendment.
Yeah, final closing comment for today's discussion.
Yes, I would say, Tarun, that Shakespeare said, in pursuit of justice, let none of us seek salvation. So whether it is the investigating agency, we as lawyers are accused, or the honorable judges, we all have our task to perform. It is this harmony, the synchronization, and we hope that all as one fraternity, one unified fraternity, we must bring in our laws into a dynamic form that is result-oriented, that is justice-oriented. That's all I would say.
My final comment is Tarun rocks for bringing the live issues that we lawyer want to comment upon.
Okay. So we'll take one last comment from Mr. Bhandari before we end the discussion.
Yeah, my final comments really is that, we are living in a situation of huge chaos right now. As I began by saying, we urgently need to bring in reforms so that secured lenders who are giving money and taking security over property, they can realize their security. If you attach that security and he gets into this endless rambling, into long investigations and never-ending disputes, then that security will depreciate, and really this shows us in very, very poor light. I haven't come across any other country where secured lending is attached in a fashion that has happened in the last few years here. So therefore, we urgently need reforms in that. Second, what if we cannot have our tribunals functioning, if you cannot provide various benches in the appellate PMLA tribunal, then please do away with the PMLA Act. Because, if you attach assets, accused persons and aggrieved persons should be able to go to a forum and get those assets detached. So therefore, we urgently need that these tribunals, whether it's the NCLT, NCLAT, or the PMLA tribunal, all three tribunals help in detaching of these assets. And therefore, we really need that these tribunals are well staffed. There has been no member in the PMLA tribunal for the last 1 year, if I'm not mistaken, and no head for the last 2 years. So therefore, I think these two things should be the takeaway. And I think this will really help in resolving some of the problems.
Well, thank you so much. In fact, we must first thank Chief Justice of India, Justice N.V. Ramana, for flying up and taking attention on this issue. We hope that in a sense, it's like catching the bull by the horn. He understands the problems of ED and CBI, but also wants to see action. I think during his tenure, we will see a lot of action. At least that is the hope from this panel. I would like to thank Mr. Abhimanyu Bhandari, Mr. Vijay Agarwal, Mr. Chaudhary, Vikram Chaudhary. I also have to correct myself. He's a designated senior. I introduced him as an advocate. So I think that correction I make on my part. Thank you so much for joining us. We will continue our series on the Enforcement Directorate and CBI as and when things happen. But that's it for now. Thank you for joining us on the show. Thank you.
Thank you, Tarun. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.